And our next speaker is a constitutional freedom lawyer who has been involved in the tax honesty and freedom movement for 25 years or so. And he became so good at beating the IRS that they even started a campaign to not let him represent people in court because they figured that with him being in court, IRS could be in trouble. They could lose cases just because they're getting a good defense. What a concept, right? You know? And so, but right now, he's got a very important thing going on, a very, I think, historic lawsuit about the 16th Amendment of the U.S. Constitution, what the government calls the income tax amendment of the Constitution. And it's of historic value and importance what he's doing, and I think you ought to know about it and consider supporting the work he's doing. But to let you know about that, I'm going to bring him himself on the podium to tell you all about it. Please help me give a warm hand and welcome to Attorney Jeff Dickstein.
Morning. Good morning. See if we can get this to work. Can we get the computer up there, please? All right. There's some people here or that aren't here that I want to talk about. Two of them are dead. Leo Masters and Vern Holland, certainly American heroes. I don't know how many of you know these people. Leo is an ex-boxer turned patriot, bulldog. You know, if there was one person in the world you knew would have your back, it was Leo Masters. I miss him. Vern Holland, someone else like that, started the Freedom Education Association. Some of you may remember RX for seizure fever, created a whole new deal on how to challenge the IRS and their levies. Great man. Rob Aldrich was my paralegal of 20 years, has an inoperable brain tumor. It hurts him to think. I'm lost without him. Great patriots, great Americans, and as long as we're here, certainly wanted to bring them up to your attention and remember them. All right, let's see if I can start this PowerPoint presentation. Well, maybe. All right, slideshow, view show. Okay, there we go. There's someone in the audience, another hero. I haven't seen this man for years. Vietnam veteran, Top Gun graduate. His wingman got shot down. Ken circled around after he had parachuted out to make sure he was safe. Ken, would you stand up? I haven't seen you in a long time. Ken took a stand, went to jail as a result of that. We have U.S. versus Mossad. I was honored and privileged to represent Ken. Jury came back with the jury instruction question. The judge gave the wrong instruction. I told the judge he was wrong. Sure enough, the Fifth Circuit reversed Ken's conviction. Good for you. You know, Payman gives out the awards, including pomegranates. But, you know, Payman makes this happen, and he makes this happen every year. And without him, we wouldn't be here talking to you. Big hand for Payman. And just like most TV crews, you never see them in the background because they're behind the cameras. But another big hand for the gentlemen who are making all of this possible. Joe had to leave. I want to thank him for his kind words. There's another man it was an honor and a privilege to represent. I'm not sure the devil could have convicted Joe. I get a lot of credit for that, but you know, not only is he a sweet man, he's integrity, he's righteous. If there were more people like Joe, this world would be a lot better place. Joe showed a picture to you folks of me standing beside some boxes. When I read the indictment and I saw that Joe had been charged with Al Thompson happened to be in jail at that time. He was at risk of flight. I put out the word I wanted to speak with Al. The word got around. Al called me. I offered to do a joint defense. Al decided to do things his way. So when I didn't want someone representing themselves in the same trial with Joe. It's not that me or any other lawyer is so special because we went to law school, but after you have X number of years experience, if you think you can walk into a court and represent yourself without having been there, without having to have the experience of what goes on, without the capacity to size up the judge, size up the jury, size up the prosecutor. Each and every case is absolutely different, even if the charges are the same. It's like a big old chess game. You have to understand not only how the pieces move and what the rules are, but then the rules change, unlike a game of chess. The court changes the rules on you if they don't like how the game's going. If you're by yourself, if you've never done it before, you're lost. It's not that I don't respect Al, it's not that I don't love Al, appreciate his heart and what he stood up for, but I didn't want them in the same trial. So that picture that you saw is I took that picture and I attached it as an exhibit to a motion to sever. And the basis of the severance is Al wanted to go to trial in a hurry because he was in jail and wouldn't waive his Speedy Trial Act. And Joe did waive his right to speedy trial to give us time to go through those boxes and prepare. The judge was forced to sever the trial. At the time, I was fortunate enough to work with the Bernhoff law firm. Bob Bernhoff's one of the smartest men I've ever met. He has a huge knack for business. He knows how to attract money, something I wish I had. But he knows how to do things properly. So I went out and watched the Al Thompson trial. Nice having a preview because they did the exact same trial when it came time to try Joe. And guess what? We were ready. It's nice to be prepared. Okay? Irwin Schiff is someone. I was about 20 minutes away from climbing on an airplane to go represent Irwin Schiff during his trial. His people were concerned that Irwin wasn't doing it right, that Irwin's evidence wasn't getting heard. 20 minutes away from leaving to get on the airplane, Irwin called me, said, you know, if I'm going to go to jail, I'm going to do it my way. Well, you know, Irwin, I don't know what the benefit is to the Patriot community for Irwin to now be serving a life sentence. I don't know what the benefit to the Patriot community is for Dick Simcannon for being in jail for 6 to 8 years. I don't know what the benefit is for Sherry Jackson. I can't say too much about that. We're in the process of trying to get a new trial based on hiring an investigator. What happened with Sherry is she got on the stand and testified that she talked to 3 or 4 of her colleagues about the income tax thing as she was doing her research. And the government called 3 of these IRS people to the stand, and they said, no, Sherry never talked to them. So the prosecutor painted Sherry as a liar. Plus, everybody on the jury does what? They file tax returns and pays their taxes. And you know what? If you don't, you're not the patriots here in this room, ladies and gentlemen. You're the enemy to the vast majority of the people. And until you comprehend and understand that, you're not going to win very many jury trials. Okay? Fred Allnut was another person. I got called in by Larry Beecraft the day before the trial started to go represent Fred Allnut and his son. I flew into Maryland. I think I was living in Alaska at the time. Flew into Maryland Sunday afternoon. We went to trial Monday. We happened to win that trial. Not guilty verdicts, conspiracy and tax evasion. But you know what? The IRS then came and seized his construction business, and Fred, who used to help people, who had a heart as big as gold, helped a lot of people, helped me, helped Bill Benson, helped Larry Beecraft. The IRS came and seized his business and took it from him, and now Fred doesn't have the money to help people. Either does Al Thompson, big-time businessman out at CenCal, or does Dixon Cannon. Okay? I'm not sure this is the way to fight, ladies and gentlemen. I know sometimes that's not the message. You know, you take somebody like John, went to jail. He's a hero. Somebody like Ken went to jail. He's a hero. Certainly some people have to go to jail. But during Joe Banister's trial, probably the biggest poster for the freedom movement, poster boy for the freedom movement, and I look behind me in the courtroom, and there may be 30 people there. You know, if you get a chance, watch the movie Gandhi again. See how many people were behind him. Until we get the people behind us, until we find out a way to motivate them, not that this isn't great, you know, that you're all here. I'm honored to be here. Thank you for what you guys are doing. But until there's 100,000 people, like John's saying, things aren't going to change much. On the way to Atlanta, I'm in line in Tulsa with the rest of the sheeple going through TSA. And one of the TSA guys came out to help speed things along, you know, nice guy. He says, well, you know, in this society, these lines are inevitable. We're going to try to keep you safe, and you need to do this, this, and this. And I piped out, well, you know, sir, in this society, what you're doing violates the Constitution. I always say something in line. I can't keep my mouth shut. So a lady in front of me turns to her husband or boyfriend, I'm not sure which, and says, well, you know what? I'm glad that this is going, that this is happening. And I said, well, you'd rather be safe than free. And she turned around and looked at me and said, are you from this country? The guest speaker last night, in that speech, he talked about reality and perception. Everybody in here has their own reality, just like everybody out there has their reality, and it's different. And what's truth? Truth is absolute, but each of our truths are different. You know, your truth is probably different from his truth. And you create your truth, and you create your realities, and you create your perceptions by what you believe. And when you fully comprehend that, then you can create the miracle that's going to be necessary for us to save this country. You know, ignore this if you want. I know this is radical stuff. There's a book out called Conversations with God. I used to wonder why my prayers weren't being answered, and then I found out they were. It's just my prayers is what's in my subconscious as opposed to what I say I want, but you always get what you want. Conversations with God is a great book to start understanding that process. There's a book and/or a video out called The Secret, How to Shape Your World. I highly recommend it. There's a wonderful video out on quantum physics, how your mind works. It's called What the Bleep. The 3 CD set is called Down the Rabbit Hole. Highly recommend it. A book out of the 60s from the civil rights lawyers and the movement and what it took, the political action necessary to be tied into the legal action, how those work in tandem, Rights on Trial, absolute reading if you want to understand how to beat this beast. And finally, The Art of War, if you want to understand how to go in the courtroom and win. They're tough to win. I've won more federal criminal tax cases than any other person in the world. And I've lost probably 75, 80% of them. Okay? It's tough. It's tough to win. Joe got lucky. All right. I'm here to talk to you about the Bill Benson 16th Amendment litigation, and what I want to explain to you is why I believe the Bill Benson 16th Amendment litigation is important to you and to me. The government filed a lawsuit against Bill Benson under the Abusive Tax Shelter Statute, 26 U.S.C. Section 6700. They're seeking an injunction to prevent Bill from falsely telling people the 16th Amendment to the United States Constitution was not ratified. That presumption that it's false is an irrebuttable presumption as a result of Supreme Court precedent dealing with what's known as the Enrolled Bill Rule. The Enrolled Bill Rule says is once somebody signs off on a bill or signs off on a constitutional amendment, that becomes conclusive on the courts, and it can't be challenged in the courts of law because it's a political question. The challenge has to go to the legislature. So the issue of whether or not the 16th Amendment was or was not ratified is closed in the courtroom. As part of the injunction, the government wants the names and addresses of everyone who either obtained, read, or purchased any of Bill Benson's material. Now, Bill Benson wrote 2 books, The Law That Never Was. I'm not selling these. I do have some ethical obligations. I can't do business with Bill. I'm not selling his book. What you can do, however, is I've got a legal pad on the desk back there. If you want a copy of the book, sign up. I'll have Bill get in touch with you. In 1984, Bill Benson went to every state then in the Union, went and obtained the documents from the archives of each state, certified copies on the ratification process in each state. 17,000 pages of documents. They're in my bedroom. I've read all 17,000 pages to get ready for this lawsuit. No question in my mind, the 16th Amendment was not in fact ratified by 3/4 of the states. Absolutely no question in my mind. Anyway, that's the basis. Bill was selling what was called a 16th Amendment Reliance Defense Package. Steve Hempling helped put that together, FES, another hero sitting right here. Thank you for all of your work, Steve. Government's also trying to enjoin Steve and his group. Anyway, the government wants the names and addresses of everybody who has Bill's material for no other reason than that they have Bill's material. The full details of the lawsuit, including the various pleadings, are on my website, jeffdickstein.com. This is what the website looks like. On the home page, come on, I explained the litigation. We've got the docket sheet. If you want, you can go on Pacer and see for yourself that these documents are actually filed. On the pleadings page, I've got the various pleadings. You can see that some of them are in blue and they're highlighted. By clicking on the number, you can actually read the pleading. This one, for example, happens to be the complaint. You can see where the document was filed. You can see the case number. You can see the date of the filing. Paragraph 8 of this complaint, Benson falsely tells customers that the federal income tax is unconstitutional because, according to his legally frivolous theory, the 16th Amendment to the Constitution, which was adopted in 1913, permits Congress to impose federal income taxes, was not properly ratified by the states. That's the allegation. When you go through here, you can click on the various pages. Hats off to Jeff Bowman, fellow up in Alaska, called me up one day, said, I looked at your website. It's pretty amateurish. Let me fix it for you. This is the result of his work. You know, my cup runneth over. Thank you, Jeff. Anyway, so the various pleadings are here. You can click on this page to buy a copy of my book. This is probably not going to be available after today. I published my book in 1990. I've got 12 copies left. When they're gone, that's it. In the book, chapters 1 and 2 discuss whether the income tax is a direct tax or an indirect tax. Chapter 3 shows everybody where the law is that nobody can seem to find. I know you all don't want to hear that, but the law's pretty clear. Knowing how it works, knowing how to defend it is an entirely different ballgame. That's chapter 3. Just like the Supreme Court said in Eisner versus McComber, the real question becomes, what is income? And is the tax as it's imposed and collected today, is it in reality the excise tax on your income derived from your labor, according to Bruchaber, or is it actually a direct tax on your labor? And that's the issue. I've addressed through 1990 every case that's ever addressed that question. I stopped in 90. I haven't updated the book. All they do now is cite the prior cases. And also Appendix A and B are two examples of cross-examination of people in actual trials that I did. We did a trial in Indiana where we raised the jurisdictional argument. What does subject to the jurisdiction mean? Are you actually in the state? Are you in the United States? Where does the United States have jurisdiction? There's nothing new under the sun here. Things might get repackaged, but I promise you, every single argument that you're studying today was out there 30, 35 years ago. A.J. Porth, the Fifth Amendment, how many times has that been recycled? How many times has the PRA been recycled? How many times has the H-61 argument been recycled? Back in 1984 and 85, when we had the Justice Symposium, because there was no place for us to get continuing legal education, we were the gurus. We all got together 4 times a year, and everybody in the Justice Symposium thought they were non-resident aliens. That was the version of the H-61 argument back then. I've always been a naysayer. Well, gee, if we're a non-resident alien, I guess you're all subject to a 30% tax. They didn't like that. Now the H-61 argument is something else, but it's the same argument repackaged. There's nothing new. There's nothing new. So you kind of have to do your homework. I've got a donate page. Come on. And on the donate page, and what this lawsuit is about more than taxes, and what's even scarier to me, is the First Amendment implications. And I'll be talking about that a little more. I've got 3 YouTube videos on here. If you have any question whatsoever as whether the First Amendment is in jeopardy, please click on here and watch these 3 YouTube videos. They're not very long. It ought to just scare the bejesus out of you. It does me. And you can make donations. I'm going to be telling you why donations are important, what it means to me, what it means to Bill, and what it means to you at the end of the presentation. But you can either donate by making a payment to me, mailing it, or if you like, you can donate through PayPal. I've tried to make it as easy and as painless as possible. And then you can click on the email page if you want to get in touch with me one way or the other. Okay, so where were we? We were there. Okay, government filed this lawsuit against Bill Benson. First thing I did is file a motion to dismiss, trick I learned by watching the United States government. You file a lawsuit against them, what do? Motion to dismiss. Okay. If, in fact, the question of the 16th Amendment is not justiciable in the federal courts, then guess what? The courts don't have jurisdiction to hear the issue. In the absence of jurisdiction, I suggested they dismiss the lawsuit. The judge decided, well, you know, gee, if I dismiss the lawsuit, then we can't enjoin Bill, so maybe I ought to have jurisdiction. So he said he did have jurisdiction. Fine, thank you, Judge, appreciate that. Of course, now you're going against Supreme Court and Circuit Court precedent, but what the hell, you know? So, we filed an answer. What was the answer? Well, our answer is the truth is, 16th Amendment wasn't ratified. So now we have an issue of fact, don't we? Was it not ratified as the government contends, or was it ratified as Bill Benson contends? It's a factual question. And then to support that, the judge invited me to file a 25-page brief on the issue. Now, if you went into court and filed a lawsuit against the government and you tried to file a brief setting forth the facts that the 16th Amendment wasn't ratified, you would all be sanctioned because that's a frivolous argument. And it took me about 8 months and 10 to 12 pleadings, you'll see the pleadings on the website, to maneuver the judge to where he would invite me to file the brief, and I didn't get sanctioned. You've got to understand how to play the game. And, you know, there's nothing special about me and the fact that I went to law school. I would imagine most of you are smarter than I am. It's just the thing that I've been blessed with an instinct and an intuition on how to proceed. It's one of God's little gifts. You know, one of the little nasty tricks that he picked me out to do this. But here I am, and this is what happened. So after we filed the 16th Amendment brief setting forth all of our issues and setting up the issues that are going to be on appeal up to the Supreme Court, you can read the pleadings. I don't want to run out of time. You can see what we did here. The government moved for summary judgment. Summary judgment is where the government or one party to a lawsuit comes in and says, look, the facts aren't in dispute, therefore it's just a question of law. And because the facts aren't in dispute, we don't need a jury. We want you, Judge, to decide that Bill Benson is falsely telling people the 16th Amendment wasn't ratified. As part of a response to summary judgment, you have to file your statement of facts. Well, based upon the brief that he allowed us to file, we filed our statement of facts, and silly things like, you know, there are 48 states in the Union at the time. The state of Oklahoma intentionally amended the proposed amendment, something that you're not allowed to do. Even Secretary of State Knox and his solicitor acknowledged that. Again, I don't want to take too much time and explain that stuff. And then like 48 minus 1 is 47. Okay? And just added them down. Each violation we could prove, ending up with the number of states. Guess what? It turns out to be less than 36. The government is supposed to then present their facts and their affidavits to counter your facts and affidavits. Well, they couldn't do that. So what did they do? They objected to the facts on the grounds that they were irrelevant, immaterial, scandalous, and pertinent. Why? Because the issue is closed to the courts. So now the judge is kind of up against the wall. So all of a sudden, the judge doesn't have jurisdiction again. And he decides, yes, the facts are irrelevant, and he struck our facts. However, he must have some pang of conscience. I'm not sure why, because that's been over 2 years and he hasn't ruled against us, despite the fact we don't have any facts to support our position. The government got real impatient about waiting for the judge to rule, so they filed a motion for discovery. And what discovery do they want? They want your names and addresses so they can investigate you. So once they did that, Bill raised Fifth Amendment grounds, says, look, the names of these people is what you're going to use to prosecute me for a conspiracy to defraud. I'm not giving you the names. So we raised that issue, besides which Bill's been under constant investigation for years and years and years because of his work. So we raised that issue and we had a status conference, and the judge tells the prosecutor, well, then why don't you guys seek immunity? So the prosecutor seeks immunity, and that took about 5 or 6 months because the Criminal Investigation Division of the IRS, who has to approve it, didn't want to approve it. But ultimately they did, and the government files its motion for immunity, and so we countered under the First Amendment. I advertised for and found 3 people. I found one person who actually purchased Bill's material and petitioned the government for redress of grievance. I found another person who purchased Bill's material and did absolutely nothing. And then I found a third person who wanted to purchase Bill's material but couldn't because I made Bill stop selling the material during the pendency of the lawsuit. Now, the Supreme Court says that John can't go into court and argue your constitutional rights. And I didn't want the government coming back, especially the Supreme Court, if and when we get there, arguing we didn't have standing. So I had 3 people, those 3 people, file a motion to intervene as John Doe 1, John Doe 2, and Jane Roe. Arguing what? Well, we can't put the names down because then the government would have the names. And then we had those 3 people together with Bill file a motion for a protective order to prohibit the discovery on the grounds that it violates the First Amendment. And the First Amendment in this country is supposed to protect us to be here, to debate these ideas, to purchase written material, to read written material, to talk about the written material without interference, especially when the written material involves allegations that the government's corrupt. No. And the First Amendment is dead in this country, or mostly dead. We're doing what we can to keep that going. Now, the last thing that happened was last week the government filed a motion for a status conference because after we filed the motion to intervene and for a protective order, the judge hasn't ruled in about 4 or 5 months. It's still sitting there. So we have 5 or 6 unruled motions that have now been pending for several years, or at least 2 years, and some of them for several months. So the government filed for a status conference to push the judge, and I decided, okay, look, if in fact the issue is precluded as a matter of law, then how does Bill get a fair trial? How does he protect his Fifth Amendment rights to due process to present a defense if the facts can't come in? So I started doing some research, and I found some cases out of the Supreme Court in the mid to late 1800s, which says when there's a conclusive presumption as a result of a non-reviewable decision of one of the branches of government, such as the executive department, which is the same position we're in here because the executive department declared the 16th Amendment ratified, then even though you can't challenge that decision, a court can exercise its equity jurisdiction to decide issues between 2 private parties involving that issue. So I argued to the judge in a pleading that I filed last week, Bill Benson doesn't have an adequate remedy at law. I've got 10 minutes, which is certainly not enough time. Bill Benson doesn't have an adequate remedy at law, and asked the court to exercise its equity jurisdiction. The hearing on that is going to be Tuesday. All right, let's quickly talk about taxes and why the 16th Amendment is important. Article 1, Section 8, Clause 1 grants Congress the power to lay and collect what? Taxes, duties, imposts, and excises. The courts have said the word taxes means direct taxes. It's different than duties imposed and excises, which are all excise taxes. Excise taxes have to be uniform. Direct taxes have to be apportioned. The Constitution says that in two separate places. This was the 1894 Income Tax Act, the one that was challenged in Pollock. The 84 Act, and I want you to see what Congress intended to tax and who. Every citizen of the United States, whether residing at home or abroad, and every person residing therein. Distinction between citizens and persons. Who were the persons? Persons were resident aliens, different than citizens. So Congress wanted to tax a citizen no matter where you lived, and resident aliens, and also down at the bottom, non-resident aliens who were doing business within the United States. And what did they want to tax? They wanted to tax gains, profits, or income from any kind of property, including salaries, rents, and employments. Different because I know a lot of you raise certain issues, or important because I know a lot of you raise certain issues with respect to that. Pollock versus Farmers Loan and Trust. Pollock was the name of the plaintiff. For those of you who don't understand these citations, Farmers Loan and Trust was a corporation. Mr. Pollock sued the corporation to keep them from paying a particular tax. The V means versus. If you're on the right side of the V, you're on the wrong side of the V. You don't want to be on the wrong side of the V. Whatever you do, that's not a good place to be. Serious penalties, especially for you folks, if you're on the wrong side of the V. I don't recommend you go there under today's political climate. 157 is the volume of U.S., the United States Reports. That's the official book where Supreme Court cases are posted. The case shows up at page 429. If there's a comma with another page, that means that's where something is cited, and the case was 1895. Mr. Pollock challenged the Income Tax Act of 1894 on the grounds that the income tax was a direct tax. It wasn't apportioned, therefore it violated the Constitution. The Supreme Court said we have to inquire what at the time the Constitution was written was a direct tax and an indirect tax, and they decided to look at the words and the language of those who framed the Constitution. You'll recognize some of these names: Madison J., Franklin, Wilson, Hamilton, Adam Smith. The Supreme Court in pages 559 to 573 reviewed what these people had to say. I suggest if you want to understand what's going on, you actually get what those people wrote and you read it. I did. The Supreme Court then said, okay, let's examine some of the decisions of 1861. Why 1861? During the Civil War, the United States Congress passed 4 income taxes. It was at the time of war. Out of a sense of patriotism, people didn't challenge it, just like nobody's challenged the victory tax during World War II. These are the cases that were reviewed. Of importance is Springer versus U.S. and Hylton versus U.S. Hylton was the Carriage Tax Act, where they taxed a carriage under the guise that it was the use of the carriage was an excise as opposed to a direct tax on the carriage. That was sustained by the Supreme Court. The Supreme Court conceded that the cases they reviewed proved that taxes on land are direct taxes. However, the cases were silent as to rent or income derived from the land. Then the Supreme Court asked a question: is there any distinction between the real estate itself and the income derived from that? The real question is there any basis upon which to rest the contention that real estate belongs to one of the great classes of taxes, in other words, direct taxes, and the income is an excise tax? Their conclusion: we're unable to perceive any distinction. They reviewed 4 more cases. Their conclusion: the law in question, as far as it levies a tax on the rents or income of real estate, is in violation of the Constitution and is invalid. Another question was had to deal with income from municipal bonds. They decided that was repugnant to the Constitution. There were 3 other questions presented. None of the judges could decide. They couldn't get a unanimous decision. Of import was question number 2 as to the income from personal property, whether that was unconstitutional. The dissent was written by Justice White. He was an associate justice in the Supreme Court at the time of the Pollock decision. His position is there's only two types of direct taxes in the Constitution: tax on land and a capitation tax. Everything else is an excise tax. If tax on personal property, according to Justice White, is an excise tax. The case was political in nature. It came back for rehearing. The Supreme Court decided it was able to broaden the field of inquiry and to determine which of the two great classes of tax upon a person's entire estate. That means everything you own. Is a tax on what you own a direct tax or an indirect tax? They were unable to conclude it was not a direct tax. That's in fact what they held. No reason to decide that capital, which you use to produce property, a tax on that capital or the income from that capital isn't a direct tax. According to the United States Supreme Court, it was in fact a direct tax. Admitting that the act taxed income of property irrespective of the source, still a direct tax. They summed up the conclusions: tax on land is a direct tax, tax on personal property or its income derived from personal property is a direct tax. It wasn't apportioned, it's unconstitutional. 4 justices dissented: Harlan, Brown, Jackson, and White. What was their dissent? There's only 2 direct taxes: tax on land and a capitation tax. Okay, 1909, President Taft calls a special session of Congress, wants to overcome the holding of Pollock. I was in Alaska at the time. It was before the internet. I went to the law library, got on the microfished every single page of the special session of Congress and read it. If you want to understand what the purpose of the 16th Amendment was, I suggest you do the same thing. 16th Amendment was proposed. Let's forget for the second whether it was ratified. Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment. A lot of people ask me, why are we doing this litigation if the Bruce-Shaber Court said that the 16th Amendment created no new power of taxation? Easy. First of all, you have to understand the context in which it was said. It's clear on the face of this text that it does not purport to confer power to levy income taxes because Congress already had that power. Number 2, the purpose of the amendment was what? To relieve income taxes when imposed from apportionment from a consideration of the source once the income was derived. There is no escape from this conclusion. The amendment was drawn for the purpose of doing away for the future with the principle upon which the Pollock case was decided. What principle did Justice White and the Supreme Court think that was? Determining whether a tax on income is a direct tax by considering the source and thereby taking it out of what? The classes of excise taxes to which it inherently belonged. Justice White, who's now a Supreme Court Chief Justice, went back to his original conclusion that the income tax is an excise tax and it doesn't have to be apportioned. Therefore, there's no new power created by the 16th Amendment. If you're a Bruce-Shaber fan, then what you have to do is recognize that you are unable to consider the source of the income. Now, taxes are either a direct tax under Pollock or an indirect excise tax under Bruce-Shaber. A lot of you folks like to look at the definition of an excise tax found in Flint versus Stone Tracy. Definition, you can look that up. I'm running way out of time. What I want to have to point out to you is that this case was decided in 1911, before Bruce-Shaber, before the 16th Amendment, and this case involved the federal corporation tax of 1909. The definition of an excise tax today, if a court was going to review it, if you follow Bruce-Shaber, would have to include a tax on income. Now, it's impossible for a tax to be both a direct tax and an indirect tax. Can't be both. If the tax is an excise tax, then arguing that your labor cannot be taxed, in my opinion, isn't valid, just like the courts say. Why? Because when you start talking about your right, your property right to earn a living, You're going back to the source, and the Brushaber case says we aren't allowed to consider the source. Something to think about, guys, when you're putting your arguments together and why they're being denied by the courts. Eisner versus McComber said what? Defined income. Definition of income is profit or gain derived from labor. Certainly the Supreme Court didn't think there was any problem taxing the gain derived from your labor despite your right to work. This is what the Supreme Court said. Don't get mad at me, okay? And then let's look at what Congress said for all of you 861 fans. Gross income from sources within the United States. I know a lot of you like to look at the regulations and say that your income and your personal services are exempt. Congress says no in the statutes itself. Gross income from sources within the United States shall be treated as income from sources within the United States, personal services compensation for labor. Okay, why is the Bill Benson 16th Amendment litigation important to us? Because if you take away the 16th Amendment, then we revert back to Pollock, and now it's an unapportioned direct tax on your labor, and y'all don't have to pay it. Okay? This litigation is about preserving your inherent right to work and to earn a living, and it's about preserving your inherent right to sit here without being charged with a hate crime or a terrorist crime, which is just right around the corner. That's why this litigation is important. I'm representing Bill Benson and the other 3 interveners for free. They don't have money. I've got some basic needs. I've got a cavity that needs to be filled. I need new eyeglasses. My car's in the shop with the busted water pump. I have to pay rent. Okay, I need your support in order to keep doing this. I can stop doing this and do something else. I hope that's not necessary. And while I don't want to talk too much about it because it's still in development, I'm working with several other people, many of whom are here, and we're coming up with a brand new strategy on something that's never been tried before to get all of the people of the United States, or a big portion of them, together, new blood, creating the political movement. And the people in the street, we're going to launch an attack on the withholding tax. Okay? I can't work on that if I'm cooking hamburgers to pay rent, okay? I'm asking you people, please support Bill Benson. Please support this litigation. I'm going to ask that the hack gets passed and you guys donate some money so we can keep up this work. Bless you for being here. Again, my honor, my pleasure and privilege. Sure.
I want to take one exception to what he said, because he said he's not too smart. I think this is one of the smartest people in the movement, and the way he can put things together. And this case is extremely important. And some of you guys, I know, don't have a lot of money, but you can commit to small monthly payments to this guy, because that case is extremely important in our opinion also. Thanks.
Thank you.